joining me today for this edition of Privacy Soundbites. My name is Stephen Reagan, and I am the Principal Privacy Consultant and Subject Matter Expert on Privacy and Data Protection Law here at Rangu. With these soundbites, I like to take an opportunity to discuss some current events within the privacy and data protection world. And today I want to talk about the decision Lloyd v. Google coming out of the Supreme Court of the United Kingdom. This is a really kind of an interesting case, and because it kind of generated a little bit of controversy and conversation within the privacy community. So the broad overarching headline is that class actions are not allowed in the United Kingdom for privacy and data protection claims. But within this overarching decision, there are some nuances that kind of carve out maybe a way forward. So I want to go through that decision, lay out some of the facts, and discuss a little bit of the reasoning for the court ultimately reaching their decision. So the factual situation arose from Google's collection of personal information on the Safari browser between 2011 and 2012. So by default, Safari and Apple had set the settings where third-party cookies were by default blocked. And this is not a new factual case, a new factual situation. Back in 2012, the Federal Trade Commission and American Consumer Protection Agency fined Google $22.5 million arising from this situation. And the FTC explained that, and I'm quoting, Google specifically told Safari users that because the Safari browser is set by default to block third-party cookies, as long as users do not change their browser settings, this effectively accomplishes the same thing as opting out of this particular Google advertising tracking cookie. So despite these default settings, Google created a workaround deploying its double-click ad cookie, which is basically an advertisement on a web page that allowed Google then to collect information through that advertisement, wherever this advertisement happened to be placed. So with this third-party cookie that Google said it was not using, Google could identify visitors on the Safari browser, whether you were using an iPhone, an iPad, or a Mac, and could identify visits again by any of these users to any website displaying an advertisement from Google. Google was able to collect information on the date and time of a visit to a website, how long the user spent there, which pages were visited, and for how long, and what advertisements were viewed and for how long. And in some cases, Google could identify the geographic location of an individual based on their IP address. So of course, Google did this without users' knowledge, without users' consent, despite giving some assurances to individuals that they weren't doing this. And what was innovative and interesting about this whole case was that Richard Lloyd argued that Google's actions violated the Data Protection Act of 1998 and tried to sue Google on behalf of 4 million people. So he tried to bring a class action suit in the style of an opt-out class action, meaning everybody within the group that was potentially harmed by Google's actions were a member to this lawsuit. And so, the suit was attempted to be brought on behalf of 4 million people. So we can imagine that the fines, if this was allowed to go forward, would really quickly escalate, and the situation can be really consequential for many of these companies. And Mr. Lloyd essentially argued that the harm arose from a common action that created a collective class that could in a sense sue Google. And this really differs from the common approach in the United Kingdom. Opt-out class actions, as I've just described, are only basically allowed in the situation of competition law. So Mr. Lloyd really tried to extend and broaden the scope and allow these actions to be brought on behalf of privacy and data protection violations. The usual approach in the United Kingdom is what is called an opt-in class action, where people or litigators attempting to sue a company have to create the class, have to get people to affirmatively opt in and join and become a party to a lawsuit. So we can take the situation of the British Airways data breach that occurred back in 2018. This was kind of one of the first headline-grabbing GDPR fines, and the fine was greatly reduced on appeal, but that's beside the point. There was a lawsuit that was in the process of developing a class action, and the litigants, the potential plaintiffs, created a website, and of the potentially 400,000 people who were harmed in this data breach, about 16,000 signed up to be a party to this lawsuit. So it's about 4% of the potential class who signed up. What Mr. Lloyd again was trying to do was, in essence, make sure 100% of that class was a party to the lawsuit, meaning the potential fines really could have a lot of teeth. And the issue of bringing privacy and data protection claims, individuals basically have three options. You can try to get some redress from the supervisory authority. Where the supervisory authority fails to take action, you can get a judicial remedy against the supervisory authority, or you can go to court and seek to get a decision against an organization in court. The problem with this is that legal cases cost a lot of money. And so often it really just isn't worth bringing these cases and bringing litigation, bringing legal action, because the cost just will greatly outweigh any potential payments or compensation you can get for these violations. So in some sense, there was a bit of hope that this new type of class action would be allowed, again, kind of redistributing the costs and potentially making it more likely that individuals would be willing to litigate for the protection of their privacy and data protection. As I've kind of built up, as I've kind of mentioned, the court did not accept this argument, and So now I want to turn to looking a little bit more in depth at the court's opinion and some of the reasoning therein. So again, Mr. Lloyd's claim alleged that Google secretly tracked the internet activity of millions of Apple users and used the data collected for commercial purposes without the user's knowledge or consent. Lloyd argued Google's use and collection of personal data violated the data protection principles because the data were not processed fairly and none of the conditions, what we know as legal basis now under the GDPR, were met for the processing of personal information. So in reaching its decision, the court kind of went through a history of opt-out class actions available in the United States and other jurisdictions, as well as looking at some of the legislative history within the United Kingdom, noting that the government had considered and rejected creating a generic class action regime in 2009, really preferring a sector-based approach. So since then, as I've mentioned, the only sector enacting a class action regime was in the field of competition law. Well, Mr. Lloyd sought to overcome this challenge by bringing a claim based on civil procedure rules, allowing a claimant to represent a class that has, quote, the same interest in the claim. Now, Lloyd argued that individuals' assessment of damages was unnecessary because a, quote, loss of control of personal data was enough to award compensation, and as a number offered for compensation was £750 per individual, producing a final result or compensation of about £3 billion. So the court went through a lengthy history and discussion of the case law of representative actions, citing a 1910 case called Marked and Co. Limited v. Knight Steamship that expressed the view that damages in representative actions were, quote, a personal relief, and that, quote, no representative action can lie where the sole relief sought is damages because they have to prove separately in the case of each plaintiff, and therefore the possibility of representation ceases. So this was really an idea that the court drew upon and basically adopted as its main source of reasoning, really looking at the idea that the harm suffered per individual was different, and thus the assessment or the allocation of compensation would be different, really based on the idea that different users use the Safari browser for different times and do different things with it, meaning that some people are going to be harmed more than others. And so again, this was really a driving point for the court, that all of the damage, all of the harms, on the one hand, harm and material damage had to be proven per individual in order to assess compensation for those damages. And so that was, really the one of the driving points that the court was trying to make. Now, the court made some interesting comments in its reasoning, in particular saying a bifurcated action could have been brought, meaning that the first part of a representative action, of a class action, could have been used on behalf of a group or a class to determine if Google was in breach of the Data Protection Act of 1998. The individual claims that could theoretically have been brought by each user who was affected then would be left for a second part of the trial, again, to determine if there was unlawful processing, as well as what damages were suffered by each individual. So that really, formed the challenge of the case for Mr. Lloyd. Nonetheless, the court went on to discuss the claim for damages and looked at Mr. Lloyd's claim that was a, quote, bottom-up approach, claiming damages on a uniform per capita basis for any contravention of the Data Protection Act. The alternative case argued by Lloyd was that each member of the class was entitled to damages assessed as an amount that, quote, they could reasonably have charged for releasing Google from the duties for which it breached. So the claim for compensation was based on Section 13 of the 1998 Data Protection Act that provided, in part, from Section 1, an individual who suffers damages by reason of any contravention by a data controller of any of the requirements of the Act is entitled to compensation from the data controller for that damage. So again, damage could not be something that could be assumed. Loss of control of personal data was not enough to create a sufficient material damage or the assumption of a material damage. Those had to be, those had to be proven. And the court also went on a discussion of this idea of loss of control of personal data, rejecting this analogy and kind of creating a distinction between some cases that had arisen in the common law privacy tort from claims arising under data protection legislation. So the court basically said that despite these two areas of law deriving from the right to respect for private life, protected by Article 8 and incorporated in Article 7 of the EU Charter, the court said that it did not follow that those two different legal regimes aiming to protect the same fundamental values, quote, must do so in the same way or to the same extent or by affording identical remedies. The court cited this as a crucial point in distinguishing this Lloyd v. Google case from another case called Halford v. United Kingdom, which was a decision from the European Court of Human Rights that awarded £10,000 for an invasion of privacy of a senior police officer whose telephone calls were intercepted by her employer. So again, this was really dispositive for the court, really crucial, that these arose, these claims, these awards for damages arose under different areas of law. So on one hand, the common law privacy tort, and on the other hand, legislation seeking to regulate privacy and data protection. This can be, of course, construed as a situation where the court really was looking to arrive at a decision and then did some logical gymnastics to arrive at the decision with the reasoning to support that type of decision. And so for all of the foregoing reasons, this brief discussion that I've just engaged in, the court concluded that Section 13 of the Data Protection Act 1998 does not confer on, quote, on a data subject a right to compensation for any non-trivial contravention by a data controller of any of the requirements of the Act without the need to prove that the contravention has caused material damage or distress to the individual concerned. Okay, so that was, again, the major outcome of the decision. Mr. Lloyd could not bring a class action. Instead, the issue of damages had to, and the issue of harm, and then the compensation for those damages was something that, again, could not be assumed and had to be proved on an individual basis. So I want to conclude there with laying out that the court did not completely or outright decide that all opt-out class actions were banned. There is this carve out for potentially for a bifurcated class action. It's not really clear if that will create a sufficient incentive or a sufficient environment for individuals to go ahead and bring these claims, these seeking remedy in the courts, where it is, again, so costly to litigate. Again, with the benefits, or not the benefits, but the compensation being so minimal on an individual basis. In this case, again, £750. I find it really hard to believe that somebody is going to litigate and go to court for £750 when the costs of the trial were just so exceed that amount. And of course, that the final amount that Lloyd offered to the court as a potential option, £3 billion. Okay, then that is something that can be then redistributed to all the members of a class and presents an incentive for people to bring legal action. But what the court did instead was favor potentially try to create an environment, a more business friendly environment, to prevent frivolous litigation from going forward, and really impeding or diverting money that can be used for other types of product development or innovation or what have you. I do want to mention a last important detail was that this case, Lloyd v. Google, was brought in the pre-GDPR era. So, it was brought as a violation of that 1998 Data Protection Act. And there are some important differences between that piece of legislation and the GDPR. So under the General Data Protection Regulation, the UK still has their own version of the GDPR that doesn't differ from the European version. And under the GDPR, Article 82, it provides for compensation even in the case of non-material damages. So, maybe loss of control of privacy under the GDPR is, maybe the case is better. Maybe the law is better at protecting, some of these interests in privacy and data protection that go along with just being able to have some agency, have control over how your personal information is used in the cyberspace. So with that, I want to close this soundbite. I hope this gave you a little bit of clarity on the case Lloyd v. Google. It was a really important case, and the outcome, the result will, in some sense, have reverberations at certainly in the UK, potentially in the EU as well, though it is probably more isolated just to the United Kingdom. Really, as the UK kind of seeks to embark in a privacy and data protection world post Brexit, they've signaled they want to be business friendly, a hub for innovation. They want to position themselves as a place where these technology companies can go and bring their money and bring potential tax revenues as well. So, with that, I will close it out, and I look forward to in some sense speaking with you next time. Have a good rest of your day. Bye.